apologize. I believe that based on the filing submitted by the defense, that the state and the defense have an understanding that the defense will not make any arguments that rise to the level of a Denny argument and not present any evidence that will rise to the level of a Denny argument. And they recognize that the argument that the state believed was a Denny argument was a sort of a connect the dots argument of some individual pieces of evidence, and they've indicated they will not make that sort of connect the dot argument that would rise to the level of Denny, and their submission reflects that. They have indicated to the court they have no additional Denny hearings that they are seeking from the court, even though the court gave them guidance if there was Denny-like evidence that they should put it in their submission. In light of that and understanding that I believe that to be an accurate interpretation of what they wish their filing to represent to the court, the parties were able to come up with a joint proposed cautionary instruction so that we did not have to have a mistrial in light of that pleading. That joint proposed cautionary instruction has been submitted to the court. All parties have copies. Does the court need me to read it, or does it stand in this record because it is a filed document?
I'll leave it to your choice or that of the other party. It doesn't need to be, but you're welcome to do so. Well,
I have no reason to. Do you, counsel? Okay, so we've come up with a joint proposed cautionary instruction. We're asking the court that be read at the conclusion of the defense's opening statement. That was the express preference by the defense counsel, which the state is fine with, so that it is in close proximity to the end of the defense opening statement. The court certainly will use its own discretion about whether it should be read at any other time, but that is the time that we are asking the court specifically to read it. The state is also requesting to the court that in light of the sort of connect the dots argument made by the defense, that the state be able to add to its witness list and to call in its case in chief a witness named Rebecca Jekyll. That's J-A-E-C-K-E-L. We intend to present some evidence to refute the implications that were raised in the defense opening argument. And I don't believe the defense has any issue with that. I believe that's the entirety of our discussions. Is that, counsel, does that? Yeah. So I believe that is the entirety of our joint discussions.
All right. Is that a fair statement?
Yes. Hold on one second.
Yeah. All right. So is that a fair statement of the situation?
Yes, with some caveat, but it is a fair statement. The caveat is that my conversations with the district attorney, as it relates to how I could perceive how he interpreted the statements made in my opening statement, I had told him that I could see how he would interpret it that way and how someone could interpret it that way, but that I'd hope he could see that we could also interpret it, the defense could interpret it in the way that we so proposed on Tuesday and also in our pleading to the court. And so there was kind of that mutual understanding that it could be seen both ways is kind of my understanding of that conversation. And so that was why we found it amenable to prepare this proposed cautionary instruction, and that would really cure any concerns that the state would have as it related to the statements that were made during the opening. As far as when we are requesting it to be read, the state's assertion was correct, that we're asking that it be read at the conclusion of the defense's opening statement. And then with Ms. Rebecca Jekyll being added to the state's witness list, naturally, no objection. She was on ours. I did confirm with the state that they will write up a summary of what was discussed with her about this text message that will be prepared and provided to the defense prior to her testifying. So we will have that information and can act accordingly when we receive it. So that's the only supplement that I have, Judge, but I think that what the state and myself have come to an agreement on is appropriate, and that the court should accept it and should allow this trial to continue.
So there's withdrawal of the motion of the state for mistrial?
Frankly, what we've tried to figure out is a way to move on at this point. So yeah, I'm withdrawing the motion for mistrial in light of the stipulations and the filing so that we can keep going.
What did I do in my life to merit such congenial attorneys? No, this is, well, I'll leave it at that. Now, this is not something which would reach an element of the offense. Well, that's the wrong reach. This doesn't actually constitute an element of the offense charge. So I don't think we need to obtain the consent of the defendant, but I assume he's familiar with the agreement and what it means, and if you want to discuss it a little bit more with your attorneys, you're welcome to do so.
If we could just have a brief moment. Naturally, I was not able to confer with my client. Can we go in the back?
Yep.
Thank you.
You know, I didn't tell the jury yesterday, I usually do, that I don't let the lawyers participate.
Mr. Krizarek is not aware of that, evidently.
I usually try to shut them down, you know, but, and I will tell you that a former member of your office, before the time that you were the High Muckety Muck,
So ancient times.
actually ended it, what's that?
Ancient times.
Ancient times.
Yeah.
Actually walked out of here with a negative score for the year. He's a very bright individual,
It doesn't sound like it.
well read, but he's impulsive and he guesses too quickly.
Yeah.
All right, I guess we got to go to work.
I have a couple of theories, but
So you've had a chance to talk with your client?
Thank you. Yes, Judge.
Okay.
Sorry.
Do you have any questions about this at all, Mr. Anderson?
No, I'm good, Judge.
Okay, any problems? Okay. All right,
back at 9?
I will accept and approve the stipulation, and it will be given as you request. If I remember to do it, at the close of your remarks, and if I do forget, just
I will remind
remind
you.
me. And other than that, I think back at 9 o'clock. And anything else?
No.
Nothing.
All right.
Thank you, Your Honor.
Enjoy this magnificent day. First day of meteorological spring.